Right, and Ms. Daly, can you hear us?
Yes, Your Honor, I can hear you. Can you hear
Okay.
me?
Yep. We're, I think, going to start with the case that you're interpreting for.
Okay.
All right, we will call the state of Wisconsin versus WILLIE.
现在叫威斯康星州对于郭林的案子，
That's 25 CM 2869.
案子号码25 CM 2869。
Right, and we have certified Mandarin interpreter Katie Daly interpreting from Zoom.
我们有 Katie Daly 翻译，通过 Zoom 进行翻译。
And Ms. Daly, if you'd raise your right hand, I'll give you the oath. Do you swear or affirm that you will truly, accurately, completely, and impartially interpret?
I do。现在是翻译员宣誓，翻译您是否会准确的、完整的、无偏见的翻译？是的。
All right, and just a reminder for counsel, you're going to have to allow the interpreter to interpret consecutively.
我现在要提醒律师，请让翻译以交替翻译的方式。
Could we get the appearances?
现在请各方陈述姓名和身份。
Carl Lazarus for the state.
考，代表州。
Wo-Chi Lin appears in person in custody alongside attorney Connor Sheehan.
郭林由律师先代表。
We've received a copy of the complaint. I'll waive its formal reading.
我们收到了起诉书，但是我们放弃阅读。
The address on the complaint is correct. I can't say at this time whether he's eligible for representation through the Office of the State Public Defender.
起诉书上的地址是正确的，但是我不能够告诉你他是否现在有可能有资格获得公众律师的代表。
Right, and Mr. Lin, if you need a lawyer after today and can't hire one, you can contact the public defender's office.
林先生，在今天之后，如果您还想请律师的话，您可以跟公众律师的办公室联系。
And if you're eligible, then they'll get you an attorney at little or no expense to you.
如果你有资格的话，他们会派遣律师代表你，很少的费用或者免费。
They've provided the contact information in that paperwork for the public defender's office.
他们给你提供了一张联系的信息纸，上面有公众律师的联系方式。
We'll make a finding of probable cause for the charge.
我们发现有理由，对你的指控有理由。
We'll enter a not guilty plea on Mr. Lin's behalf.
我们记录下来无罪，代表林先生。
And we'll hear the state's position on bail.
我们会听州说明他们的保释立场。
The state is asking for a signature bond.
州要求有一个签署的保证，
with conditions of no contact with an individual whose initials are M, R, Z.
并且无接触的命令跟这个以手写字母是 MRZ 为手写字母的人，
and a ban from the 5300 block of Leanne Lane, spelled Leanne.
而且是不能够接近53个街区的距离，跟这个人叫李安 LIANNE。
And the defense position?
No objection to the
辩方的立场是什么？
No objection to the signature bond. We
对
object to
对于签署名字的保证书，我们没有反对意见。
we object to the geographic ban and to the no contact condition.
但是我们反对就是地域上的限制，无接触，我们反对。
This was not charged as a domestic offense. The no contact has expired. The victim is not here to request that condition, and it's not my understanding that the request is being made at her behest.
这个不是一个家暴的案子，我们并没有了解到这个被害人有要求地域上的限制，所以我们反对。
It's a one-count disorderly conduct complaint, and it is taking us an extraordinarily long amount of time just to get through this initial appearance.
只是这次只是对于扰乱公共秩序的一个指控，这个花了我们很长的时间才能有今天第一次的初次出庭。
The state is asking Mr. Lin to find somewhere else to live and essentially fend for himself.
这个州要求林先生另外找到住的地方。
Considering how low the impact is of this offense, even if he were to be convicted of it, I think that that's irresponsible.
即使是考虑到这一次对他的指控，这个指控是非常轻微的，所以呢，如果限制他这个接触，有这个地域上的限制的话，那么就是太多的限制了。
And the state's response?
Yes,
你有什么反应？
my understanding, the victim is in agreement with the state's request for bond conditions.
我的理解是，这个州跟这个受害者之间有这个保金的协议。
I understand this is a disorderly conduct.
我明白这个指控虽然是扰乱公共秩序，
But it's alleged that Mr. Lin punched the victim 3 times in the head on
但
video.
但是在视频上，这个指控林先生3次打了这个被害人的头。
The state believes, at least for now, these are appropriate bond conditions sought for the safety of the victim.
我们州的认为就是这个保证是为了保护受害人的安全，所以是合适的。
Right. And, Attorney Sheehan?
The alleged victim in this case has demonstrated an ability to call 911. I think that amending the condition to a no acts or threats of violence would be an appropriate middle ground.
我是认为，这个被害人有困难打911电话，所以我觉得这个过度的保护是没有必要的。
Sure. Well, MRZ, the victim, has apparently requested or is in agreement with the requested conditions.
关于 MRZ 这个受害人，他对于这个保证的要求，他是有同意的。
The complaint alleges that MRZ and an individual with the initials JWL owns the house.
那个原告说，这个 MRZ 和 JWL 这2个人是共同拥有这个房子的产权。
The allegations are that MRZ was punched several times and the defendant allegedly threatened to kill that person.
对他的指控是 MRZ 说，这个打了他几次，然后又威胁说要杀死他。
Certainly, those allegations alone would be sufficient to get a restraining order if MRZ sought one.
就这些指控来说，如果 MRZ 想要的话，是应该获得某种禁令。
What they've done is called the police, enforced a 72-hour no contact, and apparently informed the DA's office that they would like the no contact to be in place.
他们做的事情就是给警察打了电话，做了72小时无接触的命令，然后给地区检察官办公室打了电话。
In light of that, I am going to adopt the state's request.
考虑到这些原因，我会同意州的建议。
I'll order a signature bond with a no contact condition with MRZ.
我会命令有一个签署的这个文件，然后与 MRZ 无接触。
And a ban from the 5300 block of Leanne Lane in McFarland.
然后呢，跟那个李安以及另外一个人在53个街区里面以外无接触。
Mr. Lin, is there some other address that you could stay at for the time being and get mail from the court?
林先生，在与此同时，您是否有另外的地址可以给予法庭？那么法庭可以给你通过邮寄的方式发给你通知。
The record can reflect he's shaking his head no.
让我们用记录下来，他摇头表示没有。
Couple things. If you have a cell phone number, I would suggest that you sign up for text message reminders.
有几件提醒的事情，如果你有手机的话，请给法庭你的手机号码，这样的话，法庭可以给你发短信提醒您。
You're going to get released today and you're going to have to sign some paperwork, and you can give them that phone number at that time to get signed up for reminders.
您今天就会被释放，在您被释放的时候，你要签一些，excuse me，你要签一些文件，然后在与此同时，你可以把你的手机号码给法庭。
It's possible you're going to get released in time that you could go over to the public defender's office and apply for an attorney.
也有可能今天我们释放您之后有足够的时间，您可以到公众办公室里面去，让他们给你寻找公众律师。
And their office is on the map that you were provided.
他们办公室是我们给你的那一份地图上有的。
Certainly, you're free to hire an attorney on your own if you're able.
如果你有经济能力的话，当然你可以自己请律师。
The other thing is, if you need anything from the residents on a temporary basis, you'd have to contact the McFarland Police Department.
如果您有什么需求的话，暂时的话，你可以跟 McFarland 警察办公室联系。
And you would have to arrange for a time to go with the police officers to the residents to get any items that you may need.
你必须跟警察联系，然后让警察带你去这个住处拿您的东西。
Otherwise, you can't be at that residence and you can't have contact with the victim MRZ, even if they reach out to you.
即使是这个受害者 MRZ 他们跟你联系的话，你也不可以到他的住处去。
And if you get a lawyer, they can file a motion to review the bond conditions. And if the judge decides to change those, then so be it.
如果您有律师代表您的话，那么您的律师可以代表您，对这个保证条件做出一个动议，那么法庭会考虑如果要改变还是不改变。
If there's nothing else, we'll be adjourned.
如果没有其他的话，那么我们今天就休庭了。
And Mr. Lin, you'll need to go with the bailiffs and take care of your paperwork.
林先生，您必须跟法警一起走，他会给你一些文件要您签署。
Next, Nathaniel case.
Thank you, Ms. Daly. I think you're free to go.
Okay, thank you, Your Honor.
You're welcome.
Bye.
Hold on.
Great, we'll go on the record in the state of Wisconsin versus Nathaniel case. It's 25 CF 2722 appearances.
ADA Carl Lazarus for the state.
Attorney Emily Bell appears on behalf of Nathaniel Case, who appears along with me in custody. Good afternoon, Your Honor.
Good afternoon. Did you get a copy of the criminal complaint?
I did receive a copy of the complaint. We would waive its reading at this time.
Do we have a good address?
That's the correct address on the complaint.
All right, and there's a public safety assessment. It recommends a signature bond. If you didn't get a copy of that, I assume that's in Attorney Sheehan's paperwork.
I did receive a copy of it.
Perfect. I'll make a finding of probable cause, and we'll address bail. What's the state's position on bail?
Yes, Your Honor. The state would ask for a signature bond, condition not to possess or consume any alcohol, condition not to operate a motor vehicle without a valid driver's license, a condition not to operate a motor vehicle without a functioning IID, and a condition or pretrial services referral for alcohol monitoring. I think the state's non-monetary conditions make sense, given that this is alleged as an OWI fourth, with arguably, at least as alleged, some problematic driving behavior. We believe these conditions are the minimum conditions necessary to protect the public.
Great. Any objections?
Thank you, Your Honor. We have no objections except to the ignition interlock device requirement. Mr. Case drives a work vehicle for work, and it's somewhat duplicative of the conditions for pretrial monitoring, for alcohol monitoring anyway. This incident is not have alleged to occur during work time or anything like that. So that particular condition seems onerous given the facts of this case. Again, we're not objecting to the pretrial services monitoring, which is going to monitor him several times a day and really should suffice to protect the public.
All right, and I was just checking to see whether he has an IID requirement already or not.
No, he does not. His prior was from 2017, or his most recent prior was from 2017. So it's quite dated at this point.
All right, and any response from the state?
No, Your Honor. No further argument.
All right. I think it is somewhat duplicative if we're going to monitor him with a breathalyzer through pretrial services. It also is not always easy to get an IID installed right away, and that may affect things. Whereas I'm ordering that he's going to be at pretrial services either yet today or by 10 a.m. tomorrow. I think that's sufficient. I'll order a signature bond with pretrial services. So you got to be at the 5th floor of the Dane County Courthouse and check in with them no later than 10 a.m. tomorrow. They're going to give you a breathalyzer or perhaps a bracelet that's attached to your ankle that monitors your alcohol use, and they'll report any violations to the court. I'll order that you not possess or consume any alcohol and that you not operate a motor vehicle unless you have a valid driver's license. Obviously, if there was anything out of this arrest that changes your license and whether it's valid or not, then you're not going to be able to drive. That's going to be an issue with the DOT. What about time limits?
We do want a preliminary hearing, but we would waive the time limits.
Okay. Do you know when we would schedule that then?
If you're looking at a status conference scheduled, I'd be setting that at
or on February 2nd at 1:20. If you wanted to schedule it directly for appeal, we could do that. I have dates out a month or so.
Hold on one sec. We'll take the status conference on February 2nd.
Okay, we'll take that as a waiver of the time limits and
Yes.
we'll be adjourned.
All right, thank you very much.
Next up is Carol Brooks appearing by Zoom.
Yeah.
Hello, sir. This is Deputy Huebner. I'm here with Carol Brooks.
Yep, just a second. Letting the attorney get ready.
Thank you.
All right, we'll call the state of Wisconsin versus JOVON Carol Brooks. It's 25 CM 2861 appearances.
ADA Carl Lazarus for the state.
Ms. Carol Brooks appears remotely via telephone, I believe. I cannot actually see her to confirm that she's appearing.
I believe he's appearing from the hospital, and so they're on the phone.
Understood. Alongside Connor Sheehan, Attorney Connor Sheehan. She is eligible for representation through the Office of the State Public Defender. I have a copy of the complaint. Ms. Carol Brooks, can you hear me?
Yes, again.
Can you
Yeah, I can hear
please?
you.
Have you received a copy of the criminal complaint?
I mean, I've seen it just today, but it was very vague because when I had got on.
I'm sorry. So I'm going to stop you right there just because what you're saying is being recorded. So I just need to know that you've been issued a copy and you see that as one count of disorderly conduct. That's all right now.
I just seen it. Yeah, I just seen it today.
Okay. All right. Great. So then we have a copy of the complaint. I'll waive its reading at this time. It has 1819 Aberg, so it has the job center as the best address for you to receive mail. Is that correct? Is that correct,
Yes,
Ms.
it
Carol
is.
Brooks? Okay, thank you very much.
Yes.
So then that is all I have at this time.
Right. And I'm sorry, is he going to be eligible for a lawyer from your office?
Yes.
Or does he need to get evaluated?
That's correct.
Okay. So I'll make a finding of probable cause. We'll get a not guilty plea entered. There's a public safety assessment. Reporter recommends a signature bond. What's the state's position on bail?
Yes, the state would ask for a signature bond with a condition of no contact with a Brenda Lee. And then I think there's a third initial O. So Brenda Lee O, and a ban from all Walgreens locations.
Right. And any objections?
No objection to the signature bond. Do you understand the non-monetary conditions that were asked for? They want to ban you from all Walgreens and a no contact, presumably for the employee at the Walgreens, which they allege you have spoken to. Do you understand?
Yes, I do.
Okay. Do you have any objections to any of those conditions?
I mean, this is the first I heard of it, but I don't object to it. That's fine. I mean,
Okay, no objections.
Okay, we'll order a signature bond. Condition will be a no contact, direct or indirect, with Brenda Lee O and a ban from all Walgreens locations. And we'll be adjourned.
thank you.
Montel McCarter, appearing by Zoom.
Right, we'll go on the record in the state of Wisconsin versus Montel McCarter. It's 25 CM 2865 appearances.
ADA Carl Lazarus for the state.
Montel McCarter appears remotely. He appears to be at the CCB looking through a food slot, and by attorney Connor Sheehan. Mr. McCarter, can you hear me? Give me a thumbs up if you can. The microphone's currently muted. Okay, Mr. McCarter can hear me. Mr. McCarter, have you received a copy of the criminal complaint? Thumbs up again if you have. The complaint is like the charging document. Okay, you have, great. So I would waive its formal reading. So, Mr. McCarter, the address on it is 2500 Jenny Wren Trail, but I also have the Beacon as your address. Give me a thumbs up if it should be the Beacon. Okay. So I would ask that the court amend the address in the system to be the Beacon, 615 East Washington in Madison. I believe the zip code's 53703.
I think the clerk actually has it memorized.
I'm sure he does. I'm sure I'm preaching to the choir at that point. So I think I've covered it. Oh, and he is in fact eligible for representation through my office.
All right, I'll make a finding of probable cause for the charge. We'll get a not guilty plea entered. There's a public safety assessment report. It recommends moderate cash bail. What's the state's position on bail?
Yes, Your Honor. May I just have one moment?
Sure.
Yes, Your Honor. The state would ask for $500 cash bond, or in the alternative, whatever the court believes is appropriate. The reason we're asking for the $500 cash bond is I believe this is the third pending case for Mr. McCarter. The second case, 25 CF 2108, initially had a cash bond that was reduced to a signature bond. And then there was, I believe, an alleged missed court appearance on September 15th of this year. We would also ask for a ban from the Starbucks location on University Avenue, no contact with Iran S and Julia V. And I believe that's everything. What I was checking before, in the two previous cases, competency was raised, but then I think it was established that at least at the time of that report, Mr. McCarter was competent. But I just wanted to mention that because it was somewhat recently, but no further argument from the state.
And the defense position?
Yes, I will say competency was litigated on November 3rd of this year, and he was found competent. So I'm not going to raise it at this time. I don't have any cause to. Mr. McCarter, did you hear the conditions that the state proposed? Give me a thumbs up if you did.
Yes.
Oh, okay. You've been unmuted. So do you object to any of the conditions that were raised?
I was hoping, I was hoping to get a signature bond because I couldn't afford it. 'Cause I
Okay.
didn't pay for it. But
Okay, so it's just the cash.
Yes.
I'm gonna stop you right there. I just need a yes or no. I just want to make sure you don't say anything that incriminates you. So, based on his inability to pay, my client wants me to ask for a signature bond at this time. If the court finds that to be unacceptable, I'd ask for $250.
All right, and any response from the state?
The only further comment I would add is I believe the bail bond hearing in the second case in 25 CF 2108 was just on November 3rd. And I guess it's pretty quick to pick up a new case, a third case, but no further argument.
All right. I think Attorney Sheehan's alternate offer is reasonable. It's a DC, even though he's charged as a repeater. I guess he was lucky the state decided not to charge him with numerous felony bail jumps for this particular charge. The PSA recommends moderate cash bail. There's been some failures to appear. I'll set $250 cash bail. Order no contact, direct or indirect, with Iran S and Julia B, and a ban from any Starbucks locations, and we'll be adjourned.
Commissioner, I just want to clarify, I looked at the probable cause affidavit, it looks like it's Julia B is in violin. And then I think the state had requested just the Starbucks at University Avenue. Are you ordering all Starbucks?
I'm ordering all Starbucks. And I must have misheard. It does appear that the last initial is V as in Victor.
Yes, that's my
So it'll
understanding.
be Julia V as in Victor is the other no contact. And we are adjourned.
Next up is Robin Bass, appearing by Zoom for a forfeiture.
We'll go on the record in the County of Dane versus Robin Bass. It's 25 FO 2360 appearances.
ADA Carl Lazarus for the county. And Mr. Bass appears via Zoom from the Dane County Jail without counsel.
All right, and Mr. Bass, I've got some good news. It looks like the DOC has dropped their hold. The DA's office decided to charge you with a non-criminal charge, so that's not going to hold you any longer. The charge was county possession of drug paraphernalia, so that's more like a traffic ticket. They will have an offer. If you want to accept that offer, then you can just be done with the case. If you don't, you're still going to get released. It's not like we're setting bail or anything. It's a non-criminal matter, okay?
Yes, sir.
And the offer from the county?
Yes, plead guilty or no contest for court costs only.
Great, so Mr. Bass, the court cost would be $114.50. You don't have to pay it up front like bail. If you wanted to accept that offer and enter a no contest or guilty plea, you just need to make that payment within the next 60 days or work out a payment plan with the clerk's office if you need more time. Did you want to accept that?
I didn't mean to interrupt you, sir.
No, that's all right. Did you want to accept that offer? Or do you want to contest the charges?
I mean, I really don't know how to go with this because, like I said, the stuff wasn't in my possession. It was
Okay,
unspotted.
so let me say this, Mr. Bass. They hold that offer until the next court date. So if you wanted to enter a not guilty plea, you
Can
can
we
still
do it? Can we
accept
just-
the offer at the pretrial if you decide that you want to take it, and that gives you more time to think about it. Either way, you're getting released. So you can either resolve it and accept their offer. I can't do anything better than that. That's the minimum. It's court costs.
I'll take the court costs.
Okay,
take
so you
court
want to
costs.
just resolve it today and be done with it?
Yes, and as long as it's not on my record, I'll resolve it, take the court costs, and I ain't got to worry about
Okay,
it.
well, it is gonna be on CCAP. It won't be there terribly long. I think within a couple of years, they take it off. It will notify anybody who's looking at CCAP that it's a non-criminal charge. But again, if you want more time to think about it, they keep that offer open until the pre-trial. You just need to come back for that court appearance.
No. I just want to be done with all this stuff in my life, period.
Okay, any questions you have?
No, sir.
All
Is
right,
Burger King still open?
I have no idea. But I'll accept your no contest plea to the charge, order the court costs. They'll give you the info about making the payments and you'll get processed and released yet sometime today. We are adjourned.
Next up is Alberto Velasquez. Is this the one consecutive? It is, yes.
Thank you.
Alberto, mi nombre es Pedro Esteban Intérprete, voy a interpretar consecutivamente porque parece que también hay una piscina que está escuchando. The interpreter just introduced himself and mentioned that there is also a victim, so the interpreter is going to interpret consecutively.
All right, we will call the state of Wisconsin versus Alberto Luis Velasquez.
Vamos a poner en el caso del estado de Wisconsin contra Alberto Luis Velázquez.
That is case number 25 CF 2723.
Es el caso 25 CF 2723.
We have certified Spanish interpreter Fred Svensson,
Tenemos al intérprete certificado Fred Svensson
and I'll just swear you in for a hearing. Do you
y le
swear
voy a
or
hacer
affirm
prestar juramento
that
para la
you'll
audiencia.
truly, accurately, completely, and impartially interpret the proceedings?
Jura y afirma que va a interpretar este proceso completamente bien y correcto. Yes, I do. Court interpreter Fred Svensson. Sí lo juro.
All right, and because the interpreter is going to have to interpret consecutively, you need to speak in short sentences and make sure you pause.
Y como vamos a tener la interpretación consecutivamente, necesitan hablar en pequeñas frases y dejar que haya una pausa entre las
Could we get
cosas que
the,
digan.
could we get the appearances?
Podemos tener en el acta las comparecencias.
ADA Carl Lazarus for the state.
Fiscal asistente Carl Lazarus de parte del Estado.
Alberto Velasquez appears in person in custody alongside attorney Connor Sheehan.
El acusado, señor Alberto Luis Velásquez, está presente, preso en la cárcel con el abogado Connor Sheehan.
The address on the complaint is correct. We'll waive its reading. I can't say at this time whether he can get representation through the state public defender.
La dirección de la denuncia es la dirección correcta. No puedo indicar en el acta con certeza que si él va a calificar para un defensor público o no.
All right, and Mr. Velasquez, they've given you the public defender information in case you need help getting a lawyer after today, give them a call.
Y señor Velázquez, le han dado la información del defensor público. Si es que deseas ver si le pueden asignar un abogado, debes llamar hoy después de salir de la cárcel.
And you're certainly free to hire an attorney on your own if you're able to after today.
Y después de hoy también usted puede elegir a contratar a su propio abogado también.
And Attorney Sheehan will help you for today.
Y el abogado Sheehan le va a ayudar por hoy.
Looks like there was an immigration detainer lodged, but that was declined for the sheriff's policy.
Parece que se ha impuesto una orden de detención por parte del Departamento de la Inmigración, pero por política del sheriff se ha negado en forzar esa orden.
I'll make a finding of probable cause for the charges and enter a not guilty plea to the misdemeanor.
Vamos a entrar en el acta una declaración no culpable y determino que hay motivo fundado para el delito menor.
And I don't believe we have a public safety assessment.
No creo que tenemos una evaluación de la seguridad pública.
We were told that the victim did not want to make a statement, but if they've changed their minds since I think they're on Zoom, they certainly should have that opportunity.
Me han indicado que la víctima no desea dar su declaración, pero como están presentes por Zoom, les quiero extender esa oportunidad si lo desean usar.
Attorney Lazarus, do you know if they changed their mind and wanted to make a statement?
Abogado Lazarus, ¿sabe usted si se han cambiado de opinión y quieren hacer una declaración en el acta?
Not to my knowledge.
De mi conocimiento, no.
Right, then we'll hear the state's position on bail.
Entonces podemos escuchar la posición del Estado sobre la fianza de libertad.
Yes, the state is asking for $5,000 cash bond.
Sí, el Estado está pidiendo una fianza de un valor de $5,000.
No contact with Yeshiri GH. That's YESCHERY. Last initials GH, or any of her family members. YES.
Y entonces estamos pidiendo que no haya ningún contacto con Yeshiri, iniciales GH o su familia inmediata. I'm so sorry.
Nada.
I was talking to him.
Right, and Attorney Lazarus, I don't know if there were any other conditions or argument you wanted to make.
Y señor Lazarus, no sé si habían otras condiciones o alegatos que usted quiere indicar en el acta.
And from the 300 block of North Thompson.
Que sea prohibido estar en la cuadra 300 norte de la Thompson.
The state makes these requests because this is a very serious Act 3 offense.
El Estado está haciendo estos alegatos porque este es supuestamente o alegadamente una ofensa bien grave bajo la ley de acta número 3.
It's actually 2 Act 3 offenses.
Realmente son 2 ofensas de la ley número 3.
The state believes this is the minimum amount of cash bond.
El
Under
Estado opina que esto sería la cantidad de una fianza de caución mínima.
under an Act 3 analysis,
bajo el análisis de la ley número 3.
as again, this is alleged to be incredibly violent, serious felony behavior.
Se alega que este es un crimen de un delito grave y muy violento, increíblemente violento.
This incident alleges essentially two incidents with allegedly the defendant returning a second time on the same evening.
Bueno, esto se alega que este incidente, bueno, realmente son dos incidentes porque se alega que el acusado regresó una segunda ocasión esa noche.
And the state would respectfully ask for these conditions with no further argument.
Y el Estado está pidiendo respetuosamente para estas condiciones sin más alegatos en el momento.
Right, and I don't have the benefit of a public safety assessment. Is there a prior criminal record that you're aware of?
Y no tengo el beneficio de poder ver una evaluación del riesgo al público. ¿Me puede usted decir que si hay algún antecedente penal para este acusado?
Not that I'm aware of, Your Honor,
Lo desconozco, su señoría.
nor am I aware of any ties to the community.
Y desconozco de los lazos que él tiene con la comunidad.
And Attorney Sheehan?
Y licenciado Sheehan.
Thank you, Your Honor. There are two Act 3 offenses. One is misdemeanor battery.
Sí, hay dos infracciones o ofensas de la ley número 3. Uno que es agresión, delito menor.
No objection to the non-monetary conditions.
Ninguna oposición a las condiciones no monetarias.
$5,000 is simply too much.
$5,000 es simplemente demasiado.
The allegations are quite serious. They are allegations.
Los alegatos son bien graves, pero son alegatos nomás.
Mr. Velasquez spoke with law enforcement right away.
El señor Velázquez habló con las autoridades inmediatamente.
The offense has already been amended downward once from second degree to third degree.
El cargo ya se ha modificado de segundo grado a tercer grado anteriormente.
We would ask that you set cash at $1,000.
Pedimos que se haga una determinación de una fianza de $1,000.
Right, and is there some other place that Mr. Velasquez is going to be able to reside or get mail if I adopt the no contacts, which I intend to do since everybody agrees on that?
Si fuera yo a aceptar las recomendaciones de ambas partes, algo que voy a hacer como lo han recomendado de los dos lados, el señor Velázquez puede acomodarse en algún otro lugar, como esto es la residencia de él, donde él va a estar prohibido estar.
Sí, puede dar. Sí, puede darse la dirección.
Pero no me sé la dirección exacta. Sé cómo llegar, pero no sé la dirección exacta.
I have a friend I could stay with. I know how to drive there to get there, but I don't know the right exact address by memory.
Okay.
Muy bien.
Well, I'll come back to that. The clerk notified me that the victim has a virtual hand raised, so perhaps they did want to make a statement about bail.
Bueno, podemos considerar eso, pero me ha dicho el secretario de la corte que la víctima tiene su emoji de una mano levantada, así que posiblemente quiere decirnos algo.
All right, if that's the case, they would need to unmute.
Y si es así, tienen que prender el volumen o hacer clic en el micrófono para prender el volumen de la conexión.
Hola, buenas tardes, ¿cómo están? Yo creo que $1,000 no es suficiente.
Espera un segundo, por
Sí.
favor.
Claro.
Está hablando muy rápido y el intérprete tiene que poder escuchar cuando está hablando. Espera un segundo. The interpreter stopped the victim who's appearing via Zoom because she started racing along and I could not understand what she was saying. So the interpreter stopped her, but she said, "Good afternoon, everybody." Okay, usted dijo buenas tardes todos y después dijo algo.
Yo creo que los $1000 que tiene que pagar él como fianza, no lo miro correcto, en verdad, porque él hizo una agresión sexual.
I don't think that the amount of $5,000 is a correct amount because he committed sexual assault.
Hay una menor de edad en casa y ella está con traumas, no puede dormir. Pues mi niña estaba presente.
My daughter was present and she's unable to sleep. She was in the apartment.
Yo no sé, pero yo creo que eso no lo merece ninguna mujer. Por eso es que hice esto.
Perdón, ¿qué dijo usted? ¿Él merece qué?
Yo creo que ninguna mujer merece que la abusen sexualmente, ni la golpeen, ni la agarren del pelo
No,
por
I'm
toda la
sorry,
casa.
I can't hear what she's saying. No, no le escucho, está hablando rápido y no muy claro. Por favor, puede repetir.
Yo creo que ninguna mujer merece que le jalen del pelo, que la abusen sexualmente, que
Ah.
su hija mire todo esto.
I don't think that any woman deserves to have her hair pulled and be sexually assaulted, especially in front of their child or their daughter.
No sé, yo dejaba a mi hija constantemente con él y yo tengo que llevar a mi hija a un hospital o algo para que la evalúen, pero no creo que sea adecuado solo $1000. O sea, yo creo que esto
I
es
don't think
algo
that
muy
that
grave.
amount is enough. I don't think that that amount is enough or a fair amount, considering the need to maybe have to go to a hospital.
Yo siento que, no sé, esto es muy grave. Yo nunca he pasado por algo así y nadie lo merece.
I feel that this is a very delicate situation. Nobody deserves to be treated like this. This is the first time this ever has happened to me.
Esa persona debe de pagar por lo que hizo.
That person should really have to pay for what they've done,
A mí, especialmente a mi hija con el trauma.
especially to me who endured all that trauma.
Nada más quiero decir eso. Y
That's all I
gracias.
want to say. Thank you.
And that was Yasheri GH by Zoom for the record. Thank you, ma'am.
Gracias, señorita. Y para que conste en el acta, eso fue indicado por Yasheri GH por video Zoom.
I normally would have taken that statement first, so I should allow counsel a chance to respond to that information.
Normalmente hubiera escuchado esa declaración antes y permitido que los abogados pudieran responder.
Attorney Lazarus?
Yes, in response to the defense's argument that this was reduced from a second-degree sexual assault to a third-degree sexual assault.
Sí, para responder al alegato de la defensa que esto había sido reducido o que se haya reducido de segundo grado agresión sexual a tercer grado agresión sexual.
That was an initial charging decision, as the state is still waiting on laboratory testing.
Eso fue una decisión inicial para decidir los cargos, como el Estado todavía está esperando recibir resultados del laboratorio.
The state's investigation is ongoing,
La investigación del Estado está continuando,
but just based upon what the victim has just said,
pero basado en lo que se ha indicado por la víctima
based upon what is alleged in the criminal complaint,
y basado en lo que es alegado en la denuncia,
the state truthfully believes this is the minimum amount of cash bond with these non-monetary
con
conditions.
toda sinceridad, el Estado piensa que esto debería ser la cantidad mínima y con estas condiciones, considerando los alegatos.
I mentioned the state's belief in the significance of the fact that Mr. Velasquez came back to the apartment after an initial incident of domestic violence. In the state's opinion, that's indicative of especially concerning and violent behavior under an Act 3 analysis.
basado en las creencias del Estado y el hecho significativo de que el señor Velázquez regresó al apartamento después del incidente inicial. Eso nos deja al Estado la opinión de que esto es un crimen violento, un comportamiento, un comportamiento serio bajo el análisis de la ley número 3.
No further argument.
Ningún otro argumento.
Attorney Sheehan.
Y abogado Sheehan.
Thank you, Your Honor. I don't wish to comment on the statements of the alleged victim in this case. That's not my place, and I don't want to pay her any disrespect at this time.
No voy a hacer ningún comentario sobre los comentarios de la víctima. No le quiero faltar el respeto y no voy a hacer comentarios sobre lo que ella ha indicado en el acta hoy día.
But the state's comments I have to respond to because
Pero necesito responder a los comentarios del Estado.
just looking at the elements of second and third degree sexual assault, that doesn't make sense.
Porque considerando los elementos de una agresión sexual en el tercer grado y otro en el segundo grado, no hace sentido.
And his return to the apartment later that night is also indicative of his living there. Living there.
Y el hecho de que él haya regresado al apartamento una segunda ocasión esa noche es algo indicativo nomás de que él estaba viviendo ahí.
He has no criminal history to speak of. And
Él no tiene ningún antecedente penal.
if there are concerns over potential harm coming to the alleged victim or to her child, then these can be addressed by means other than cash.
Y si existe la potencial, si existe una potencial de lastimar al menor o a la víctima, entonces esos pueden ser dirigidos por condiciones aparte de una fianza de caución.
All right. Well, today's purpose of the hearing is not a sentencing.
Bueno, el propósito de la audiencia de hoy no es para la condenación.
It's to address bail, and I have to look at several factors in determining an appropriate amount of bail.
Y para considerar una cantidad apropiada de una fianza, necesito considerar ciertos factores.
The amount of bail isn't meant as punishment or a sentencing or to make the victim whole for what happened. Certainly cash couldn't do that in this type of instance.
En un incidente como este, la consideración de la fianza no es para considerar el tipo de castigo o para compensar a la víctima o para decidir la condena en esta etapa del caso.
And the defendant has not been convicted of anything here today.
El acusado no ha sido condenado por algún crimen hoy día.
I do have concerns about appearance without cash bail.
Pero sí tengo dudas sobre la comparecencia del acusado sin tener una fianza de caución.
It sounds like the ties are somewhat limited and those ties are getting severed by some of the bond conditions.
Parece que los lazos que él tiene con la comunidad son un poco limitadas y se van a romper considerando las condiciones exigidas de fianza.
But we also have a very serious felony charge that, if convicted, may well involve prison time.
Pero también tenemos un alegato bien grave, que es un delito grave y que puede resultar en un castigo de la prisión.
And that could be significant prison time. We don't know.
Y puede ser un tiempo largo en la prisión, no lo sabemos todavía.
That provides a pretty substantial reason not to want to appear for the charges.
Pero eso da una o proporciona una razón de no querer presentarse para los cargos, para contestar los cargos.
The allegations in the complaint, I think, are a credible statement.
Los alegatos en la denuncia son creíbles.
The jury's going to have to decide whether that meets the burden of proof that the state has at a trial.
Los miembros del jurado van a tener que decidir si el Estado ha llegado a poder comprobar los cargos a la carga de la prueba.
I think it is significant that I believe the defendant admitted to every physical act that the victim said occurred. with the caveat that he's alleging consent for some of the acts or defense or self-defense to some of the acts.
Es también significativo que el acusado haya admitido a los actos físicos indicados en la investigación con la explicación que ocurrieron por el consentimiento de la víctima o por poder defenderse a sí mismo.
So it appears to be a fairly strong case for a type of charge that is often a very difficult case to prove.
Parece que, aunque este normalmente es un caso difícil a comprobar, el Estado tiene un caso bien fuerte contra el acusado por los
Because
hechos.
there are Act 3 eligible offenses, I have to also do an analysis as to whether cash bail is necessary to protect the public.
Y también como son ofensas bajo la ley número 3, también tengo que hacer un análisis para determinar si una fianza de caución o de dinero es adecuado.
The victim's statements, I think, are pretty significant to me, that they're concerned about whether the amount of cash bail would be sufficient to protect them and make sure that Mr. Velasquez appears.
Basado en las declaraciones hechas por la víctima, estas declaraciones son bien significativas y me hacen pensar que la víctima está preocupada por su seguridad y si la cantidad de la fianza será suficiente para protegerla.
On Mr. Velasquez's favor is there's no prior criminal record, and that is certainly something that needs to be taken into account in the analysis.
En favor del señor Velázquez, hay que también considerar en el análisis si hay algún antecedente penal y en este caso no lo hay.
I think the state has done that.
Pienso que el Estado ha hecho eso.
If we had somebody who had a prior criminal record who was alleged to have committed these charges and had the limited ties that they do, an amount much greater than $5,000 probably would be ordered by me.
Pienso que el Estado ha hecho el análisis bien, porque si una persona con estos alegatos se presentaría aquí con antecedentes penales, la cantidad de la fianza sería bastante más alta que los $5,000.
So I'm going to set $5,000 cash bail.
Así que sí voy a concretar la fianza en $5,000.
I'm going to order the no contact director and direct with Yasheri, GH, and any of their immediate family members.
Y voy a determinar una fianza, imponer una fianza con la condición de no tener contacto con Yesheri, GH, ni miembros inmediatos de su familia.
As well as a ban from the 300 block of North Thompson Drive in Madison.
Y también una prohibición de estar en la cuadra 300 norte de la Thompson, Madison.
The only way you'd be able to return there to get any items is if you're in the presence of the City of Madison Police Department.
La única manera para volver a esa dirección sería en presencia del Departamento de Policía de Madison.
If you're not in the presence of law enforcement, you can't be there, and you certainly can't have any contact with the victim or any of the family members.
Y menos de estar ahí con las autoridades de la ciudad de Madison. No puede estar en esa cuadra 300 norte de la Thompson por ningún motivo y tampoco puede tener contacto con Yesheri ni sus inmediatos miembros de familia.
I would suggest that you sign up for text message reminders.
Sugiero que se registre para recordatorios de audiencias por mensajes de texto.
You can do that when you're signing your paperwork.
Eso lo puede hacer cuando está firmando la fianza.
I think you're definitely going to want to hire an attorney or contact the public defender's office to be evaluated given the serious nature of the charges.
Dado la gravedad de los cargos, pienso que usted sí va a querer contratar a un abogado o contactar a las oficinas del defensor público a ver si le pueden asignar uno.
And certainly a lawyer can file a motion to have the bail and bond conditions reviewed.
Y con seguridad, un abogado o abogada puede presentar a la corte pedimientos para volver a considerar una fianza más baja o con otras condiciones.
As to time limits for the preliminary hearing?
Sobre los límites de tiempo para celebrar la audiencia preliminar,
Please keep the time limits in place.
por favor, mantenga en su lugar los límites de tiempo.
All right, we will be adjourned. Thank you.
Muy bien, estaremos concluidos.
Is it the only one for Friday? No. Friday, it was almost a half an hour. Do you want a break between?
Sure.
This case? Okay, good.
Have to be
let me check
somewhere
to see if we
3.
have someone up for Zoom real quick. Macbeth, are you ready to? I send the next one will be quicker. Praise the Lord. Next up is DELLIYANO Black, hearing by Zoom.
Recommend a signature.
It's amazing how fast 30 minutes can go by when you're
Yeah, maybe from
in your brain, maybe not to others.
They're all different.
All right, we'll call the state of Wisconsin versus DELLIYANO Black. It's 25 CF 2712 appearances.
ADA Carl Lazarus for the state.
DELLIYANO Black appears remotely and alongside attorney Connor Sheehan from the State Public Defender's Office. Do you have a copy of the criminal complaint? You've been unmuted, so I should be able to hear your response.
Yes, I do, sir.
Okay, thank you, Ms. Black. Do you understand the charges that you're being charged with? You have felony damage to property, criminal damage to property, the misdemeanor, and then felony bail jumping and misdemeanor bail jumping.
Yes, I do, sir.
Thank you. So we'll waive any reading of the complaint. Ms. Black is eligible for representation from my office. She is actually currently waiting to be appointed an attorney in 2 other pending charges. Ms. Black, the address we have on the complaint is 300 FEMRIGHT Drive in Madison. Is that correct?
No, that's where I lived long time ago at Tellurian, sir.
Okay, so should we,
I
do
don't
we
get
update?
mail. I can't get mail there anymore. They want to collect my mail. Purposely, they want to collect mail.
Okay, so should we update it to the Salvation Army?
Yes.
Actually, I'll tell you what, I think they're gonna ask for a geographic ban from the Salvation Army, given the facts of the complaint. Is there another address we could use?
No, also, sir, I won't have anywhere to live because
I tell you what, I'm gonna
I don't
stop you
have
right
any
there.
money.
We shouldn't litigate the facts of what's going on right now. I just need to know if you have another address. If you don't, that's okay for now, but there's nowhere else we
No,
can
I
put it down?
don't.
Okay, thank you. So I would ask the court to either leave FEMRIGHT in now or just take one off for the time being, and that's all I have.
All right. We'll make a finding of probable cause for the charges and are not guilty plea to the misdemeanors. And I don't believe there's a public safety assessment. What's the state's position on bail?
Yes, Your Honor. The state would ask for $500 cash bond, a ban from the 600 block of East Washington, and a ban from the Salvation Army and Goodyear Automotive locations. The reason for those requests are because this is the 3rd pending case. The second case, I believe, had an IA just a week ago. I think 3 days prior to when this 3rd incident is alleged to have occurred. It's pretty quick to pick up another felony case, including, well, I guess there's multiple felony counts alleged, felony criminal damage to property and felony bail jumping. At this point, the state has concerns that the defendant will not comply with their bond conditions, including appearing in court, and the state believes some amount of cash bond is appropriate.
Right, and Attorney Sheehan?
Thank you, Your Honor. As the court and all parties have just heard, Ms. Black is about to be banned from the Salvation Army, I assume. I don't know where else she has to go, and I don't imagine that she has any money. It is a term of confinement if she is ordered cash bail at this point. I assume my client would ask me to object, and I personally am going to object to the ordering of cash bail. I understand that property rights is something we value as a society, and that we can't turn a blind eye to the seemingly arbitrary destruction of glass windows. That being said, I would still object and ask for the imposition of a signature bond. If there are any non-monetary conditions regarding pretrial services or anything else, then those should be discussed and brought up, but at this point, I have to object based on the fact that it's just going to result in her confinement.
All right, well, I don't remember whether the state asked for cash bail at that hearing, but I presided over that. I ordered a signature bond. I don't remember what the arguments were. I did quickly look at that underlying felony case because my recollection was it was essentially the same sort of thing, throwing a rock through a window, that we have here. And then we've got the misdemeanor case, also in November. That was a criminal damage. I don't know the specifics in regards to that. It's concerning. The defendant is making a promise or a pledge every time they're signing a signature bond that they're not going to pick up any new charges. That's the most basic of condition. And it appears that in short order, they went out and did pretty much the same thing allegedly as they were alleged to have done just about a week ago or so. I don't see any way around cash bail at this point. It is still a nonviolent property offense. I'll set it at $350. I think the Salvation Army clearly doesn't want the defendant back. I think that's what maybe precipitated the behavior. So I will order the ban from the 600 block of East Washington Avenue, the Salvation Army. I guess I wasn't clear as to whether you intended, I don't know if there's other locations. That's the one I was aware of. Are you seeking a ban from other Salvation Army locations?
I don't believe so. I will mention, I requested the 600 block of East Washington ban. I think the Beacon might be in that block.
Oh,
So
yeah.
the state would
Got the
retract that.
wrong, thinking of the wrong address for the Salvation Army.
I believe the Salvation Army is 6:30, the 6:15.
That's correct.
So the state would withdraw the 600 block of East Washington ban. I do think maybe it's appropriate, given the victim, or alleged victims, a ban from all Salvation Army locations and all Goodyear automotive locations.
Okay, well, I'll adopt that, but I won't order the 600 block of East Washington. So maybe Ms. Black can seek resources at the Beacon. And
Thank you, Your Honor.
should we set a prelim in the next 20 days?
I see that there's one set currently.
That's something together.
Wonderful.
Okay, we are adjourned.
Thank you.
Next up is Felipe Jimenez, MOCTEZUMA. Felipe?
We'll call the state of Wisconsin versus Felipe Jimenez Montezuma. It's 25 CF 2718 appearances.
ADA Carl Lazarus for the state.
Felipe Jimenez Moctezuma appears in person in custody and alongside attorney Connor Sheehan. We've received a copy of the complaint. The address on it is correct. He is not eligible for representation through my office at this point. That's all I have. Thank you.
All right, and the bailiff is handing you the public defender info. So if you can't hire an attorney on your own, you could reapply with the public defender. You could apply for a county appointed attorney. That's the middle option, and the public defender can point you in the right direction to get that done. I should note we have certified Spanish interpreter Fred Svensson. I've sworn him for our hearings this afternoon already. I'll make findings of probable cause and are not guilty plea to the misdemeanor. State's position on bail.
Yes, Your Honor. The state would ask for $500 cash bond. A condition not to consume or possess alcohol. A condition to not operate a motor vehicle without a valid driver's license, and not to operate a motor vehicle without a functioning ignition interlock device. The reason, and also condition of no contact with police officer Andrew Carrera, except for law enforcement purposes. The reason for the cash bond request is that there was a prior failure to appear on March 10th of 2021 and May 6th of 2021, which I believe led to a forfeiture of $1,400 in bond money. And then I believe cash bond was added in later cases, but I'm not certain of how the exact procedural history of the cases back in, sorry, the exact procedural history of those cases back in 2021. And then cash bond was added at a later case. No further argument.
And Attorney Sheehan.
The state wants fireworks to puedo pagarlos, mi esposa puede venir y cantar de los. My wife could maybe come by in the afternoon. So you could make, it's a matter of, something de pagar $500 entonces. Yo creo que sí, eso estaría usted de acuerdo que yo hace pues esa cantidad de estaría la fianza de caución, prefiero otra cosa. No está, mi esposa no puede tomarlo. Okay. They also want you to have an ignition interrupt device. Ellos también están exigiendo que se instale el aparato que bloquea la encendido del vehículo para polímetro. Do you ever track your lights? Manejo del carro de su esposa. No. No, supposed to make sure. Ellos no están pidiendo que se instale en el equipo de su esposa. No.
Thank you. No objection to. The only condition I want to clarify is that while Mr. Jimenez Moctezuma will not drive, his wife owns a car. Is an implication of the bond condition that his wife will have to get an ignition interlock device installed while he is on bond.
I didn't understand it that way, but Attorney Lazarus can clarify. I thought it was that he's just not to operate a motor vehicle that doesn't have a functioning IID, not that he has to have all of the vehicles that might be under his control or ownership to have an IA.
That's correct?
That's correct.
No objections.
Okay, so I'll set $500 cash bail. Order that you not possess or consume any alcohol, that you not operate a motor vehicle without a functioning ignition interlock device or without a valid driver's license. I'll order a no contact direct or indirect with Officer Andrew Carrera, except as necessary in the ordinary course of Officer Carrera's duties as a law enforcement officer. As to time limits.
Pero voy a poner el aparato en uno de los carros míos, el alcoholímetro, pero me piden licencia. So in order to install one of those devices in my car, they ask for me to have a license, which I don't have. And so you just can't drive, no, where's my? You know, tengo licencia, anybody else? Okay. Okay. You have to have a preliminary hearing. Usted tiene derecho a hacer la audiencia preliminar dentro de y no have a lawyer, se da tiempo, pero usted no tiene un abogado todavía. Suggest sugiero que usted abandone o renuncia al límite de tiempo y tratar de darle más tiempo para conseguir una copia.
Time limits will be waived.
Okay, we are adjourned.
Gracias. Claro. Gracias.
Next up is ELIN Guardado Espinales.
Okay. I think this is gonna. Okay. And just take it from there. Yeah. We'll see what non-monetary conditions are. Let's move forward and take it from there.
We'll go on the record in the state of Wisconsin versus ELIN Guardado Espinales, 25 CF 2717 appearances.
ADA Carl Lazarus for the state.
Mr. Guardado Espinales appears in person in custody alongside attorney Connor Sheehan. The address on the complaint is correct. We've received a copy. I'll waive its reading. He is eligible for representation through my office. He has not been appointed an attorney as he has no other open cases.
Great, I'll make findings of probable cause and are not guilty plea to the misdemeanor. There is a PSA report that recommends a signature bond, state's position on bail.
Yes, Your Honor. Just checking one thing. Yes, Your Honor. The state would ask for a signature bond, a condition of no contact with victim one, who is Steve, last initial D, a ban from Cherokee Marsh Park, and a condition of no controlled substances or drug paraphernalia without a valid prescription.
And any objections?
No. I have to, for the record, object to the duplicative condition of no controlled substances or paraphernalia without a valid prescription, as it is already legal to do so. I understand this court's position, but I still have to object.
Fair enough, and I understand other commissioners or judicial officials look at it differently. I think it's helpful to remind the defendant that it is a condition of bail because it is against the law, and you have a condition in all of your bails that you're not committing new crimes. So I'll order a signature bond. The conditions will be a no contact, direct or indirect, with the alleged victim with the initial, or not the initials, Steve D, that she be banned from Cherokee Marsh Park and that she not possess or consume any controlled substances or drug paraphernalia without a valid prescription. He's entitled to a prelim in the next 20 days.
We'll waive the time on this.
Okay, we are adjourned.
Yeah.
Is there, I'm just, can I ask for
You can ask a question. I think he's worried you're gonna say something that'll be used against you because we're recording. So I think he'd prefer you say it quietly to him and he can make sure that it isn't something that's gonna incriminate you.
This is just like trial, right? This is just like a set.
This right now is just bail.
Okay, so we're not gonna go into detail.
No, absolutely.
Okay. Oh, okay, then I'll just wait for that.
Yes, they'll appoint you a lawyer and then you talk to them. You guys figure out what your strategy is for.
Oh, sounds good. Thank you.
Good luck.
Thank you.
Take care.
Okay, we are adjourned.
Next up is Kirby-ROBINSON, appearing by Zoom for a forfeiture.
All right, we'll go on the record in the County of Dane versus Kirby-ROBINSON. It's 25 FO 2356 appearances.
ADA Carl Lazarus for the county. The defendant appears via Zoom from the Dane County Jail without counsel.
Right, and sir, the good news is that you're not getting charged with a crime. The DA's office decided to charge you with a forfeiture, county obstructing, resisting an officer. That's non-criminal, more like a traffic ticket. The bad news is I think there's a DOC hold that's still in place and I don't have any authority to do anything with that. But with respect to the charge that the DA's office has filed, this is the type of thing where they're going to have an offer. If you want to accept that, you can be done with that particular charge. If you don't want to accept it, it's not going to affect your custody release one way or another. So we'll see what the offer is.
Yes, to plead guilty or no contest to the charge for court costs only.
Okay, so if you want to accept that, that would be $114.50 to be paid in the next 60 days, or work out a payment plan if you need more time to pay. It's not like bail that needs to be paid up front. Did you want to accept that offer? Or do you want to contest the charges?
Sir, respectfully, all I was trying to do was resist because I didn't want to. I had to go to the hospital because I just died, and they were telling me to get out of the hospital. So when I was resisting, it was resisting because I didn't want to go to the anywhere without being checked out. That was it. So when I was
Okay.
resisting, I didn't want to go to the go to the jail and end up dying or something because I wasn't.
Okay, so do you want to have it set for
wanna
further
talk to-
proceeding?
Is it okay if I could talk to somebody to see what my rights are before they just, I know it's
Well,
nothing.
you're not entitled to an attorney because this is not charged out as a crime. Today's not the trial, so I'm not hearing the evidence, and I can't really do anything better than what they've offered. So if you don't want to accept that, that's fine. If you want to think about that, they also keep that offer open until the next court date. And again, this is a non-criminal charge.
Can I just think about it? And for the next court date, I don't want to be, I just don't want to just keep plead out and stuff.
Yeah,
Especially
no,
after I just
that's a
died and
reasonable
they're-
position. Yeah. So what we'll do is we'll enter a not guilty plea. Oops, we lost Mr. Bowman.
Right here.
All right.
I'm here.
We lost the video anyway. So Mr. Bowman, we'll get a not guilty plea entered. Is the Beacon a good place for you to get mail?
Yes, sir.
All right, and then I do need to advise you, in case you decide that you want to have a trial at the end of this with a 6-person jury. If you want a 6-person jury, you need to make a written demand within 10 days of today's date and post $36 in non-refundable jury fees. If you don't do that, then the judge would hear all the evidence and be your 1-person jury. If you don't have any questions, we'll be adjourned.
Thank you, sir.
Yep, you're welcome.
Next up is Willie Thomas.
We'll go on the record in the state of Wisconsin versus Willie Thomas. It's 25 CM 2866 appearances.
ADA Carl Lassers for the state.
Willie Thomas appears in person and in custody alongside attorney Connor Sheehan. The address on the complaint is correct. We've received copies. I'll waive its reading. Mr. Thomas actually has counsel appointed to him, probably through the State Public Defender's Office, as he is eligible for representation. That's all I have right now.
Okay, and there's a DOC hold right now. Should we use the jail or do we want to use the Fordham Avenue address or someplace else for mail?
I believe that the activation hold has been dropped, maybe since
Okay. Where should we send mail, Mr. Thomas?
the Beacon.
Okay, we'll update that to 615 East Wash. I'll make findings of probable cause, enter not guilty pleas to the charges, and state's position on bail.
Yes, Your Honor. The state would ask for a signature bond and a ban from all Walgreens locations.
Right, any objections?
No objections.
Okay, order a signature bond, conditional B though, that you be banned from all Walgreens locations. And we'll be adjourned. I think if that hold was dropped, you're getting released, okay?
All right. Take care.
Yeah, you're welcome.
Next up is Austin King, appearing by Zoom. Another closer.
One second.
Somebody else did it. I didn't need to do anything else with you.
All right, well, call the County of Dane versus Austin King. It's 25 FO 2358 appearances.
ADA Carl Lassers for the county. Mr. King appears via Zoom from the Dane County Jail without counsel.
Right, and Mr. King, the good news is they've decided not to charge you with a crime. You're getting charged with county disorderly conduct, so that's non-criminal. The bad news is it looks like there's a DOC hold that may still be in place. I can't address that. You'd have to talk to your agent about that. But with respect to the new non-criminal charge that they've charged you with, they're going to have an offer and we'll see what that is.
Yes, Your Honor. The state would offer to resolve this case for a plea of guilty or no contest for court costs only.
Okay, so if you wanted to accept that, sir, that would be $114.50 to be paid in the next 60 days, or work out a payment plan if you need more time to pay that. It's not like something you have to pay up front. Did you want to accept that offer, or do you want to contest the charges?
I'll accept that offer.
Okay, I'll judge you guilty based on your no contest plea to the charge, where you pay the court costs. They'll give you some info about making the payments, and then again, you're gonna have to talk to your agent about getting the hold lifted. We'll be adjourned.
Thank you, Your Honor.
Yep, you're welcome.
Next up is Robert SEAWRIGHT for a forfeiture. Robert. SEAWRIGHT.
Call the County of Dane versus Robert SEAWRIGHT. It's 25 FO 2359 appearances.
ADA Carl Lazarus for the county. Mr. SeaWright appears in person, in custody without counsel.
Right, and Mr. SeaWright, some good news, you're not getting charged with a crime. They charge you with county disorderly conduct, so that's non-criminal, it's more like a traffic ticket. It's not gonna hold you in custody, I don't see anything else that's holding you. I think you're getting released today no matter what. They will, however, have an offer, and we'll see what that is, okay?
Yes, to plead guilty or no contest for court costs only.
Okay, court costs will be $114.50. To be paid in the next 60 days, or work out a payment plan if you needed more time.
Okay.
Did you want to accept that, or do you want to contest the charges? All right, I'll judge you guilty based on your no contest plea to the county disorderly conduct charge, or to the court cost of $114.50 to be paid. They're going to give you the info about making the payments, and you'll get processed and released yet today, I believe, okay? Yep, you're welcome. We are adjourned.
Next up is NICHOLAS LEE WEY, appearing by Zoom. What's that?
Right, we'll go on the record in the state of Wisconsin versus NICHOLAS LEE WEY. It's 25 CM 2867 and 25 CM 2870 appearances.
ADA Carl Lazarus for the state.
Mr. Way appears remotely over Zoom alongside Attorney Connor Sheehan. He appears to be in seg. Mr. Way, can you hear me?
I think they're muted.
Okay, they are muted. Can you give me a thumbs up if you can hear me? Oh, no, he's unmuted. I'll hear you if you say yes, Mr. Way. Can you hear me?
Yeah, that guy just showed me a paper. I asked to read it all, but he didn't let me. I'm not sure what's going on. I'm not really sure, but yeah, I can hear you. Sorry.
Okay, thank you. So have you received a copy of the complaint? Have you received a copy of the charging document in this case? It says, or I guess case is, that you've been charged with resisting, misdemeanor bail jumping, and disorderly conduct with the use of a dangerous weapon.
I didn't hear Mr. Way's response.
Okay.
There's 2 criminal complaints. Did you get copies of those, Mr. Way?
He's provided copies of that. He's on a tactical feed right now, so we're unable to give him the paperwork, but I have explained it to him.
Okay. Then, let's see here. Mr. Way, the address on the complaint is 29 Quail Ridge Drive in Madison with a zip code of 53717. Is that correct?
He said yes.
Okay. And he is not eligible for representation through the State Public Defender's Office.
Okay, so Mr. Way, Attorney Sheehan will assist you here today. If you can't hire an attorney after today, you can always reapply with the public defender or apply for a county appointed attorney, which is the middle option. I'll make findings of probable cause in each of the cases and are not guilty, please. State's position on bail.
Yes, Your Honor. In 25 CM 2870, the disorderly conduct with use of a dangerous weapon, the state is asking for $250 cash bond, conditions of no dangerous weapons as defined by statute, no contact with Forrest B or Isabella B, and a ban from the Planet Fitness in Verona. In 25 CM 2867, the state is asking for, again, $250 cash bond with conditions of, again, no dangerous weapons. The reason for the modest cash bond amount requests are because these are now the second and third cases Mr. Way has within a relatively short period of time, I think approximately 3 or 3.5 months. The state believes some increase in cash bond is appropriate. I noticed that both these cases were picked up, I guess, within the same 24-hour period. And then the resisting case appears to allege, or obstructing case appears to indicate some lack of compliance with law enforcement, indicating that Mr. Way may not come to court voluntarily. I was also looking, I couldn't tell, but I guess Mr. Way was arrested and booked out of jail on the disorderly conduct, and then later that evening was arrested by a separate police department. I only mention that for bond analysis purposes, and no further argument.
Yeah, so I think in the 2870 case, he's posted $150 cash bail, but there was a note that the court hadn't received it yet from the Dane County Jail, but he had posted the bail for that particular case and then maybe went and got himself rearrested in short order. Attorney Sheehan, your position on bail?
Thank you. Mr. Way is unemployed. His entire income is Social Security disability insurance. That is where that $150 comes from. It is basically 10% of everything he had to live on for the month. That being said, a young man living on SSDI, that is very clearly a mental health issue. Also, he's not charged with stalking, and yet the ban is from the Planet Fitness, nothing having to do with the gas station where this allegedly occurred. I appreciate the state's concern. I appreciate the fact that it has an interest in protecting the community. That being said, the behavior that was exhibited based on my reading of the complaint is closer to what I would loosely consider sovereign citizen behavior, not I'm not going to show up to court behavior. So I would object to the amount of bail. I would ask for signature bonds certainly in the disorderly conduct, use of a dangerous weapon case. I would ask for a signature bond. 250 in the obstruction case. I would ask for $150 at most.
All right. Any response from the state?
I would just say, as it relates to disorderly conduct, I guess unless Mr. Way has a reason to be at the Planet Fitness in Verona, which he may very well have a reason to go there. I don't know if I don't think he works there. I don't know that he's a member there or not, but if he has no reason to be there, I would suggest that that's an appropriate bond condition.
I'm sorry, that's not how people's rights work. They don't have to justify their ability to go places in this country.
I just meant that as the least restrictive. The victim indicates he goes there. I don't necessarily want Mr. Way and the victim to run into each other again.
I could interrupt. Battery is dying. This picture of the receiver right now is actually frozen.
Oh, well, then we should pause until that's fixed.
Sure.
I assume battery means more than a few seconds. Who do we have next?
Yes.
All right.
We're gonna go with Timothy Childress.
Well, Mr. Childress. That's address correct.
Call the state of Wisconsin versus Timothy Childress. It's 25 CF 2716 appearances.
ADA Carl Lazarus for the state.
Timothy Childress appears in person and in custody alongside attorney Connor Sheehan. He's received a copy of the complaint. The address of 1928 Third Ave is correct, and he is eligible for representation through the Office of the State Public Defender.
All right, I'll make findings of probable cause and are not guilty pleas to any misdemeanors. State's position on bail.
Yes, Your Honor, may I just have one moment to. Yes, Your Honor, thank you. The state is asking for a signature bond condition to not operate a motor vehicle, to not possess or consume any alcohol. And the state would also ask for pretrial services with either I guess a cam bracelet or a remote alcohol monitor. I think the non-monetary conditions are appropriate as this is alleged to be an OWI fifth and also one causing injury to a victim. I was checking, I don't believe OWI second or more causing injury is an Act 3 offense.
I don't believe if it's a simple injury as opposed to great bodily harm or a death. Any of the charges are Act 3 eligible, but I can double check that again.
I think Your Honor is correct. And I think that was the source of confusion. There was, I think the original referred charge, well, there was a thought that there might be great bodily harm in this case, but we don't have evidence of that now, and the state is not charging that crime. But the state has no further argument.
Any objections?
One moment. No objection to the non-monetary conditions or the signature bond, just to encourage Your Honors going forward with that agreement. He did stay on the scene. That it shows hold on, don't say anything about it. He did stay on the scene. He identified himself as the driver. In the PC affidavit, it says that he disclosed having consumed alcohol in response to the officer's questions. This is charged as an OWI fifth, so he knew he had prior convictions. This demonstrates that he's clearly not a flight risk, and I just think he's frankly an ideal candidate for pretrial services or the signature bond. So I would ask the court to go forward with the recommendation.
All right, and Mr. Childress, Attorney Sheehan's just trying to protect your rights and not have you say anything that gets used against you later on. They are serious charges. I don't know what the ultimate outcome of this case is going to be. I took a look again. I don't believe any of the charges are eligible for Act 3 treatment because it wasn't charged as great bodily harm for the injury OWI. Just want to take a look at the prior history. All right, well, the only standard is whether Mr. Childress is going to show up in court. I think there's some arguments that could be made both ways. Certainly, it's significant that you didn't flee the scene and go on a chase. We see that far too often. I haven't heard about any failures to appear for Mr. Childress's history or any real prior history other than the OWI related stuff. I've got a joint recommendation from experienced counsel. I'm supposed to give some deference to that. I'll go along with the signature bond on the condition that you report to pretrial services and be monitored for alcohol use. You're going to have to be there by 10 a.m. tomorrow. It's too late in the day to get there now. That's on the 5th floor of the Dane County Courthouse. That's the map to their offices. They're going to equip you with a breathalyzer or a bracelet to make sure that you're not using alcohol. I'll order that you not operate a motor vehicle at all, that you not possess or consume any alcohol at all. And it's really important that you follow this. So we don't really have a lot of options other than cash bail if you can't make this work, Mr. Childress. Any questions about going to pretrial services tomorrow by 10?
No.
Okay, as to time limits,
We'll waive the time limits.
okay, we are adjourned.
So make sure. Doing this. Give them in here. It's a trial. Okay, so take care.
Next up is SAGAYE GAYE.
Well.
We'll go on the record, in the state of Wisconsin versus SAGAYE GAYE, it's 25 CM 2862 and 25 CM 2863 appearances.
ADA Carl Lazarus for the state.
SAGAYE GAYE appears in person in custody alongside counsel Connor Sheehan. He's received a copy of the complaint. Will waive its formal reading. Is this address correct? Yeah. The address of 3560 Breckenridge is correct. He is eligible for representation through the Office of the State Public Defender. That's all I have.
Okay, I'll make findings of probable cause. Enter not guilty, please. There's a public safety assessment reporter recommends modest cash bail. What's the state's position on bail?
Yes, Your Honor, the state would ask for a cash bond in the amount of $900. My understanding is there's been a recent history of failures to appear, or somewhat recent history, including a bench warrant in 24 CF 1327 on July 2nd of 2024, a bench warrant in 21 CF 222 on February 16th of 2024, and then going back a little further, a bench warrant issued in 21 CF also 222 on April 5th of 2022. My also understanding it's that at some point cash bond was set. I don't know if it was ever posted, but it was set at $300 and I believe 6 misdemeanor cases, all from 2025. I don't know the status of those. I think those cases are all closed now. I don't know whether or not Mr. Gay was able to bond out on that cash bond amount. But the state believes that cash bond is appropriate at this time, and that amount is appropriate. Did Your Honor call 2 cases?
Yes.
Okay. I just saw that. So 2863, that argument the argument I just made relates to 2863. And there were also non-monetary conditions being requested of ban from all Home Depot locations, all Walmart locations, all Hy-Vee locations, and all TJ Maxx locations. And then in the other case, 25 CM 2862, the state is asking for $500 cash bond with a ban from Sierra Trading Post. Again, all Home Depot locations, and a ban from all Woodman's locations. I think the state's argument is largely the same that it made for the other cases. And ultimately, we'll defer to the court as to what cash bond, if any, is appropriate here.
And Attorney Sheehan?
Thank you. I can speak to the outcome of those cases. I actually represented Mr. Gay. They resolved. He did not have $300 for any of them, let alone all of them. As far as his failures to appear, I can't speak to 21 or 2022. I can speak to about several months ago when he waived revocation in order to resolve cases and voluntarily accepted a jail sentence. I would just say that asking for $900 in one case and then saying, oh, I'll defer to the court for the second case, I think brings to light the arbitrary nature of the amount being asked for. And I would say
It was for both cases.
for both cases.
Yeah, or in the alternative for both.
In the alternative for the both deferring to the court, then I would say if he's willing to defer, I would ask the court to set it below that. I would say 600 for both cases is a reasonable amount to ask for, considering that it is functionally academic, as at this point, any cash bail is going to keep him in custody. So at that point, I would ask the court to set it at 600 for both, as in collectively, as a starting point from which we can start to file motions, because he will remain in custody as long as there is cash bail.
All right, well, given the recent failure to appear, the history where he was apparently just on cash bail recently, I assume those are all resolved because these aren't charged as bail jumps. I'll set cash bail at $600 in each of the cases. In 25 CM 2862, a ban from Sierra Trading Post, Home Depot and Woodman's locations. And then in 25 CM 2863, I want to make sure I didn't miss one when I was writing those down. All banned from all Home Depot, Hy-Vee, TJ Maxx, and Walmart locations. Am I missing one?
I'll check right now, Your Honor.
I believe that's what I heard.
Commissioner, that was $600 in each case or $600 total?
600 in each of the cases.
I have TJ Maxx, Hy-Vee, Walmart, and Home Depot.
Okay, I think I covered it then, and we'll be adjourned.
And next, we're going to be revisiting Nicholas Way, appearing by Zoom.
All right, we'll go back on the record in Nicholas Way's cases. That's 25 CM 2867 and 25 CM 2870. Appearances are as before. I'm not sure if everybody finished with all of the arguments before we broke last time. I've got the conditions written down from the state, so I think they were finished up. I'm not sure if you were done with your argument or where
I was finished with my argument regarding the non-monetary conditions. I was specifically objecting to the ban from Planet Fitness insofar as it reflected a general lack of focus on the state or addressing the girlfriend of the named victim and saying that there was no cause for it. It wasn't a nexus of the offense itself. It happened at the gas station, which isn't even being asked for. And then ADA Lazarus responded, well, the named victim goes to that gym, and I would hate for them to run into each other. I believe that was the last comment that was made.
All right, and anything else, Attorney Sheehan?
No objection to the possession of dangerous weapons as defined by statute. No objection to the no contacts. I would just again restate the fact that any bail is coming out of Social Security disability insurance, criminalizing mental health issues, which are obviously manifesting in antisocial behaviors, is a thing that we do often, and I would ask that we not keep them in custody.
All right, and I do want to clarify a point. I'm looking at the Spillman records. I'm not sure that he did post the 150 and got released. I think maybe he just posted the 150 in the one case and was still in custody on both of the cases. And if the clerk's seen something different, I certainly want to hear that. I think it does make a bit of a difference if he had just gotten released and then picked up another case. It looks to me like that's not what happened.
I just thought. The Spillman records that I'm reviewing are consistent with what you initially indicated. It looks to me that Mr. Wade was arrested on a date November 27th at 2:30 p.m. He was released November 27th, 3:30 p.m. after posting the bail, and then rearrest on November 28th, about 2 a.m.
All right, appreciate that. Anything in response to that information from the state or defense?
No, Your Honor.
No, you're.
All right, let me take a closer look at things here.
I guess while we're talking about it, I'm looking at Mr. Way's prior bookings. It looks like there was another recent booking that was, arrest on November 20th. He has an out of custody appearance date for that after posting bail of January 22nd. I don't know if the state is aware of any charging decisions that were made in that, or if they can receive reports yet. I can give you an agency case number if that would like.
Sure.
That is Middleton PD agency case number 25-17613.
Middleton 25-17. Is that what we said, or?
17613.
I don't believe we have that referral.
Based on the timing, I think it would be unlikely that your office would have received all of the reports from the arresting agency yet, since the IA date is until January 22nd.
Okay, understood.
All right, well, it's concerning. Mr. Way was out on bail. He picks up the case, posts $150 cash bail, and then is arrested. Again, we have the resistive obstructive behavior. The charges with the knife end up being Act 3 eligible by virtue of the dangerous weapon charge. I'm not going to put any weight on this other arrest on November 20th. I don't know anything about it. I don't know whether there's going to be any charges there. I think there's a need for some cash bail at this particular point in time. Probably on the light side, I guess I'm not going to ask for more than the 150 that's already been posted in 25 CM 2870. Order that he not use or possess any dangerous weapons, as that is defined by the state statutes. A no contact direct or indirect with both Forrest B and Isabella B. I guess I'm not going to order the ban from the Planet Fitness. Obviously, if either of these victims are there, he can't be there. He's got to go the other way. I think it is a bit overbroad and unnecessary. And in 25 CM 2867, I'm going to set $250 cash bail, order that he not use or possess any dangerous weapons. That term is defined by the state statutes. I think there could be an argument that those bails ought to be flip-flop, but I'm not going to do that because of the issue with the amount that's already been posted in 25 CM 2870. It hasn't gotten to the clerk, so I'm trying to make it as simple as possible and not have Mr. Way held in custody beyond his ability to post the $400, which is the total amount of bail between these cases that I'm trying to set. We are adjourned.
Next up is Ariana Lytle.
Great, we'll go on the record in the state of Wisconsin versus Ariana Lytle. It's 25 CT 632 appearances.
ADA Carl Lazarus for the state.
Ariana Lytle appears in person and in custody alongside attorney Connor Sheehan. We have a copy of the complaint. I'll waive its reading. The address is correct, and she is eligible for representation through the Office of the State Public Defender.
Right, probable cause has been found. We'll get a not guilty plea entered. State's position on bail.
And Your Honor, is this just the 632?
That's
single case?
the only thing I'm aware of.
Okay.
Unless you're aware of other cases.
No, Your Honor, it's just a bail hearing we're hearing.
Well, it's an initial appearance. So what happened was, it looks like there was an adjourned initial appearance set for September 18th. Then that was adjourned for the state to provide actual service. Looks like they were not able to serve her because efforts were made to do that. A warrant was issued when she didn't appear on October 20th. I'm not sure that she had personal service or notice in these cases or for these court dates. It looks like she may have turned herself into the jail. Is that what
Yes.
happened, Attorney Sheen?
That's correct.
All right. But we got to do the initial appearance with bail and bond conditions.
The state would ask for a signature bond with the condition not to operate a motor vehicle without a valid driver's license.
Any objections?
No objections, Your Honor.
Okay, order a signature bond condition will be that you not operate a motor vehicle unless you have a valid driver's license, and we'll be adjourned.
Thank you.
Next up is Katie Menzel, forfeiture. Right.
No, assume that's right. It looks like there was personal service of the original initial appearance, except they gave her the wrong date. It was the date, the actual date. That makes sense why the warrant got issued on that date. All right, we'll call the County of Dane versus Katie Menzel. It's 25 FO 2361 appearances.
ADA Carl Lazarus for the county. Ms. Menzel appears in person in custody without counsel.
And Ms. Menzel, the good news is you did not get charged with a crime. They charged you with county disorderly conduct. So that's non-criminal. It's more like a speeding ticket as far as severity. Didn't see anything else holding you, so I think you're getting released today no matter what.
Dude, I'm sorry.
Yeah, what's the question?
They put in no contact with my daughter and I have no clue. We live in the same house. It's my house.
Well, the clerk, I think, is gonna be able to tell you whether there's a 72-hour no contact that's still in place. I don't have any ability to do anything with that. We're not setting bail here, but I can't drop the 72-hour no contact. If
Okay.
one's in place and it hasn't expired, the victim would have to do that. But what's charged here is non-criminal. They're actually gonna have an offer. If you want to accept it, then you can be done with the case. If you don't, that's fine. You're still gonna get released no matter what.
The county offers to resolve the case for a plea of guilty or no contest for court costs only.
Okay, and court costs will be $114.50. Did you want to accept that and enter a no contest or guilty plea to the charge, or do you want to contest the charges?
I'll accept it and plead no contest. Can I have a little time to pay that because
Yeah, you don't have to pay it up front like bail. You get 60 days to pay. If you need more time than that, just contact the court and arrange for some payment plan. I
Okay,
think they do require something up front before they'll, put you on the payment plan to extend it beyond that, but you wouldn't have to pay the full amount.
okay, yeah.
So I'll judge you guilty, order the court costs. They're gonna give you some info about making the payments. Do we know if there's a 72-hour no contact that's
Yes.
still in effect?
We're still expire this according to the jail computer tomorrow night at 10:06 PM.
Okay, so you want to make sure that you don't go back and violate the
How do I get?
72-hour no contact, because that's a criminal charge. You could get arrested and brought right back to jail.
What do I do about my glasses? I have no glasses. I have.
If you gotta
This
get
one.
any necessary items from the residents, the only way you can go about that is contacting the local law enforcement agency for Preserve the Peace and go with them.
I'll just wait till the 10 o'clock tomorrow.
Okay,
Okay, thank you. I
Yep,
apologize.
yep, that's fine. We'll be adjourned if there's nothing else.
Next up is Deshinaro Kirby-Robinson. Right this one.
Sorry.
What's that? Kirby-Robinson.
Call the state of Wisconsin versus Station R.O. Kirby-Robinson is 25 CM 2864 appearance.
ADA Carl Lazarus for the state.
Mr. Kirby-Robinson appears in person and in custody alongside Connor Sheehan. The address is correct. We'd waive its formal reading, and he is eligible for representation through the Office of the State Public Defender.
Okay, so it looks like there might be a DOC hold that's still in place.
That's my
I'll
understanding.
make a finding of probable cause and or not guilty plea. What's the state's position on bail?
Yes, Your Honor, my office is asking for $1,000 cash bond. I believe the reason for the request is there's history of failures to appear. I believe there was one on November 14th, 2023, May 16th, 2023. Those are the only failures to appear I'm aware of. And we would just ask for non-monetary condition of a ban from from all Madison Metro buses.
Okay, and Attorney Sheehan?
Yeah, the charge is one count of disorderly conduct with a repeater enhancement because of, I believe, prior counts of disorderly conduct. One of the alleged victims in this case, quote unquote, specifically said, I do not want him banned I just didn't want him coming back tonight. So we would object to the ban. Again, the alleged history of failing to appear is 2 instances from 2023 and 2024, I believe. So I think $1,000 is extraordinary, especially given the fact that he's on appeal hold. I'm going to ask for $250 because I think going for $1,000 to a signature bond is unreasonable, but a no drink or the appeal hold to be dropped and $250 is, I think, more than appropriate given the facts.
Okay, and any response from the state?
No, Your Honor.
Well, I noted the same thing that Attorney Sheehan did. I think the Madison Metro worker specifically indicated they didn't want him banned for life. They just didn't want him back there on that particular day, I think, because he was intoxicated and causing problems. Had they had a different position, I'd probably be ordering the ban. There's far too much nonsense that goes on Madison Metro, and they shouldn't have to put up with that. But I'm going to set a $250 cash bail. I think that's reasonable given the failure to appear history, taking into account it is a DC, and order that you not possess or consume any alcohol. I'll just order a no acts or threats of violence towards CF. I think that was the particular individual. That way, if you do go back and you're having contact, you got to be nice about it. Otherwise, you're going to pick up additional charges. We'll be adjourned.
Next up is Gerald Walters.
So, go on the record, state of Wisconsin versus Gerald Walters is 25 CF 2719 appearances.
ADA Carl Lazarus for the state.
Gerald Walters appears in person and in custody alongside Attorney Connor Sheehan. We've received the complaint. The address on it is correct. We'll waive its formal reading. He is not eligible for representation through the Office of the State Public Defender at this time.
Okay, Mr. Walters, they're going to give you the public defender info in case you need it after today. Attorney Sheehan is going to help you here today. You're certainly free to hire an attorney on your own. If you're not able to, you can apply for a county appointed attorney. That's the middle option, or reapply with the public defender. I'll make a finding of probable cause for the charges, and are not guilty pleas to the misdemeanors. There's a PSA report. It recommends a signature bond. State's position on bail.
Yes, the state is asking for a signature bond, a condition not to operate a motor vehicle without a valid driver's license, a condition of no alcohol, and instead of a request for an IID, the state is asking for a referral to pretrial services for remote breath. The only fact I'll note of arguably significance, I believe the OWI 3rd and Rock County case 24 CT 84 was resolved just in June of this year. It resolved for, I think, a 90-day jail sentence. So I don't believe Mr. Walters is on supervision related to that case. It resolved. I don't know if the 90 days had just ended prior to this incident is alleged to have occurred, or if there was credit, but it was rather recent. I think that fact, and the fact that this is alleged to be an OWI fourth, makes the state would argue the request for pretrial services with remote breath a reasonable one.
Okay, any objections?
Yeah, we object to the pretrial services. I mean, it did resolve just in June, but it was a 2024 case. The complaint was filed in March 2024. So while the timeline is, while it was a prolonged case, I don't think that's terribly uncommon in OWIs, and I would ask the court to just view that fact in context.
Okay, let me take a closer look at things. All right, well, obviously we have to make difficult calls on pretrial services, or we might run out of slots for a valuable resource. My concern is he was already ordered not to be operating a motor vehicle because he didn't have a valid license. He was supposed to have an IID. He didn't do that, and we're here for a fourth offense in relative short order. And I'm concerned about the public and whether Mr. Walters is simply going to follow these non-monetary conditions that I'm going to order without somebody monitoring and checking up on him. So I'll order a signature bond, but I want you to go to pretrial services. You got to be there by 10 a.m. tomorrow. The deputy's handing you that map, and they're on the 5th floor of the Dane County Courthouse. So just adjacent to here. This is the public safety building. The courthouse is right next to it on the corner there. And then they're gonna equip you with a breathalyzer or a bracelet to make sure you're not using alcohol, order that you not possess or consume any alcohol, and that you not operate a motor vehicle unless you have a valid driver's license, I believe was the request. As to time limits for a preliminary hearing.
Would you rather? Pretrial services is just basically instant. You don't need cash to make sure you come. Do you need to make sure you don't drink? No objections. We were asked, I apologize. I believe your question was whether we'd waive time limits.
Yeah.
We will waive the time limits.
All right, and so sir, pretrial services is really just to monitor that you're not using alcohol. They'll give you something to blow in and they'll talk to you in greater detail about that. Or they'll give you a bracelet to make sure that you're not drinking alcohol, and you got to be there by 10 a.m. tomorrow at the latest, okay?
I think you're close today. It's on the 5th floor, I believe.
Yep,
Pretrial.
5th floor of the Dane County Courthouse. That's that yellow piece of paper.
Yeah. Yeah,
Yeah, just make sure that you're there. They'll explain all of it in greater detail to you tomorrow, okay? But you don't have to post a cash bill. I think you're getting released today, okay? All right, we are adjourned.
Next up is David Mortensen for bail bond hearing.
We'll call the state of Wisconsin versus David Mortensen. It's 25 2139 appearances.
ADA Carl Lazarus for the state.
David Mortensen appears in person and in custody alongside attorney Connor Sheehan.
Okay, we're here on a bail bond hearing after the defendant failed to appear October 29th of this year for a pretrial conference. I think he had been found eligible, but they didn't have a lawyer. Is that still where we're at, Attorney Sheehan?
That's my understanding, yes.
All right, and then the last address we had was the Beacon. Is that still the best place to get mail, sir?
Sure.
Okay, and any info you want to provide about the missed appearance, Attorney Sheehan?
Yes. In hospital, due to COPD. And those homeless. Yeah, and. And my dad's 93 years old.
So what I'll say is this, Your Honor, it's one, it just sounds like Mr. Mortensen has been through a great deal. He's taken care of his very elderly father. He's been in and out of the hospital due to his COPD. He is homeless, he is unemployed. I assume this motion was filed pro se by one of my managers as a non-party filing. Pardon me. The charge is one count of disorderly conduct. The case was opened in September. There was a failure to appear in October. He's been in custody since November 27th. I would ask the court to release him with another signature bond and a new court date. We'll just be back here again if he gets cash with another pro se bond motion. He is approaching, if he does not already have time served for a one count DC complaint. Once he gets an attorney, he can close this case out. I would ask the court not to make him sit and accrue credit he doesn't need. There are obviously plenty of circumstantial things going on in his life. I think he was fundamentally confused. I don't, obviously that's not a exculpatory defense to failing to appear. But I think that given the circumstances, having sat in custody since the 27th is a significant and sufficient penalty.
Okay, and Attorney Lazarus state's position?
The state is asking for a signature bond with the same non-monetary condition of a ban from the CITGO in the 700 block of East Washington.
Okay, I'm willing to go along with that. I'll reinstate the signature bond with the prior condition with the ban at the CITGO. You gotta keep on top of your court dates. Attorney Sheehan's right. You could potentially end up doing more time than is allowed by statute if you keep missing court and getting picked up on bench warrants. You don't want that to happen. This is the type of charge that can often be resolved pretty easily with a lot of heartache. So make sure that you show up to your court dates, okay?
Yes, Your Honor.
All right, we are adjourned.
Get out. Get out.
Good luck to you.
That's everybody.